Well, I guess we better get started. We were supposed to start at 6 and we're only 12 minutes late, so I think we're doing pretty good. My name's Angus McIntosh. I'm the Executive Director of the Range Allotment Owners Association. It's an association for allotment owners, people that own grazing allotments, either within a national forest withdrawal or a grazing district, or there's even grazing allotments in national parks, Indian reservations, national grasslands. And this is an organization that my good friend Chuck Sylvester helped me start a few years ago, and Chuck is here, and he deserves a lot of credit for helping get this started. There's never been an association that represents allotment owners. A lot of people say, well, what about the Public Lands Council? Well, all right, we'll get into that as we go on, but a grazing allotment is not public land, just so you know. You know, sometimes we would like something to be what we want it to be, but unfortunately, in the law, words have meaning and they have definitions, and we don't get to pick what those definitions are. Those definitions are what they are. And a grazing allotment is not public land. Okay, you may wish that it was public land, or you may not like that it's not public land, but the term public land has a very well-defined, clear meaning in the law. And if you go into a court of law trying to argue that a Volkswagen Beetle is a commercial semi, you're just wrong. Okay? The law applies to only certain things, and if Congress passes a law that applies to public land, then it applies to public land. You can't twist it around and say that it applies to a grazing allotment. All right? The problem is most people that are allotment owners don't even know what the heck an allotment is. They don't even know there's a difference between public land and an allotment. I've seen this time and time again. I worked for the Forest Service. I retired from the Forest Service. I'm a retired PhD, USDA, rangeland management specialist. And I also worked for New Mexico State University for the Range Improvement Task Force. I was an adjunct professor at Texas A&M. I've done consulting since about 1996, so for ranchers. And a few years ago, Chuck and I were talking, and Chuck thought, man, we need to get an allotment owners association, an association that represents us, that represents allotment owners. And I used to be an allotment owner also. My family owned a ranch over here between Duncan and Safford, Arizona, for several generations, and we sold that I don't know, probably a little less than 10 years ago to a cousin. So it's still in the family, but we're not involved in it anymore. Chuck is an allotment owner. How many allotment owners are there? Just raise your hand of the people that are here tonight. Okay. This talk is going to be geared heavily towards talking about the rights of allotment owners, but a grazing allotment is a split estate. Okay, it's not public land, it's a split estate. And as we get into this, I will explain to you how that works, what that means. Here's my background. If you want my bona fides or my resume or whatever you want to call it, this is my list of experience here. Okay. Of all these, I think the most important is this bottom one. Admitted expert witness in the federal courts. I've given expert testimony in 6 different federal courts. Okay, anybody can claim that they're an expert, but to really be an expert, you have to go into court and be examined or questioned and cross-examined, and the judge has to determine that you are an expert. So I am an admitted expert witness on these issues, and I've given testimony and expert reports on this in 6 different federal courts. Okay, so I'll just get into this. The way I usually do these presentations is I give the presentation, give it all the way through, and then at the end I take questions. So if you have a question while I'm going through this, please jot it down. Please write it down. I will answer your question. Okay, but it's a fairly long presentation, and if I don't try to stick with the slides and get through it, then we'll be here all night, because we can get off on a tangent and asking questions and take 15, 20 minutes answering one question. So I'm just going to try to go through this. Write your questions down or remember them, and at the end I will answer or try to answer any question that you have. Okay. Let's see. Oh, I need to stick this. I did that before, and I took like 15 minutes trying to figure out what was wrong with my computer. So, okay, now, looking at this map right here, here we go. Federal public land, surface and subsurface. Okay, I did not make this map. This map was published by the Bureau of Land Management, Department of Interior. This is their map. Okay. Now what does this say exactly? Federal public land, surface and subsurface. So what this map is really showing are interests that the United States owns that are either surface or subsurface. All right? And a lot of people don't realize that the West largely exists as a split estate. Okay? And the reason is because, well, several different things. But we'll talk about that as we go along. But the point is, the law under which the eastern part of the United States was settled did not really fit the conditions of the West. And so Congress enacted 2 different land disposal sets of land disposal laws. And as we get into this, I'll explain what they are, where that comes from. But the term public land itself has a defined meaning. Now you can go back home to your home county, wherever you are, go to the courthouse, and there are going to be at least one of 3 different sets of encyclopedias in the courthouse. Either if it has a law library or somewhere in the courthouse, there's going to be words and phrases, or corpus juris secundum, or American jurisprudence. And you can go into any one of those and pull out the volume that starts with P and look up the term public land. There is a definite set definition of the word or the phrase public land. And public land is land that is owned by the federal government that is available for disposal. Okay? If it's not available for disposal, it is not public land. That is a key ingredient of the definition. So back in the 1800s, there was lots of public land. Nowadays, not so much. And let me ask you a question. Can you go out and homestead in a national forest? You can't. Okay? There are land disposal laws that apply to national forest and grazing districts and national grasslands. Okay? Chuck, name one of them. I'm putting you on the spot. What kind of entry can you make in a national forest?
Grazing, timber.
Timber, okay, there you go. Not grazing, but you can make a timber entry. It's called a timber sale. Okay, so you can acquire property in a national forest, a timber sale. What other kind of entry can you make in a national forest? Mineral. Okay, you can take out a oil or gas lease or a mining claim. Okay, but you cannot claim the surface. You can't apply the Homestead Act or any other law in a national forest, and the reason is because the surface right already belongs to someone else. It belongs to the allotment owner. An allotment, according to the Supreme Court, is analogous to a homestead. It is a grant of a property right, a surface property right. Okay, so when this says federal public land, surface and subsurface. So all this red land, or these red blotches, have something, an interest in them that can be acquired. Okay, predominantly it's going to be mineral rights. All right. Now, I was told a long time ago, when you give a presentation, tell the people what you're going to tell them, and then tell them what you're going to tell them, and then tell them what you just told them. Okay? So, this is what I'm telling you guys. If there's anything, and I do this early because you might fall asleep later on in the talk. Okay? So, we'll get this out of the way early. This is section 6, subparagraph I, of the National Forest Management Act. Okay, October 22nd, 1976. This is the actual act. Okay, it's in, there's the citation where you can look it up. I always recommend that you look up any law and use the statutes at large, because the United States Code is not the law. Okay, the United States Code is written by a federal agency called the Office of Law Review Counsel. And it's made up of nothing but a bunch of lawyers that work for Congress, and they have their own little office in Washington, D.C. There's probably 50 of them. And what their whole job is to, every time Congress passes a law, an actual law like this one, a statute, they take that and they read it over and they say, okay, this section here looks like it applies to the mining laws, okay, or the Treasury or whatever. And they take that section and they say, we got to make this fit into the already existing law. So they'll take that and they'll go into, if it's dealing with minerals, they'll go to Title 30 of the United States Code. And they'll flip through it and they say, this looks like it'll fit good here. But you know what? We need to change the language a little to make it harmonize with the law that's there. So they actually wordsmith it, and sometimes they actually change the language. I'm not kidding. So the United States Code is not the actual law. This is the actual law. The statutes at large, if you want to know what Congress passed as a law, you go to the statutes at large. You do not look in the United States Code. There are things that are missing from the United States Code. Laws that Congress has passed that have been purposely left out. Okay? This says right here, this is talking about permits. Section 6 talks about permits. And it says, all permits shall be revised as soon as practicable to, or all forest plans shall be revised as soon as practicable. I know it says it's all permits. All permits will be revised as soon as practicable to conform to the forest plan. Okay, so what's that saying? It's saying your permit must be changed to reflect what's in the forest plan. If they say they want 10,000 wild horses and 5 cows, then that's what the permit shall be amended to do that. And it goes on and on, this section right here. That's how it starts out. But then you get all the way down to the very last sentence. And it's like, oh, by the way, all this other stuff that we said you got to do, forget it, because this is what matters. Any revision in present or future permits, contracts, or other instruments made pursuant to this section shall be subject to valid existing rights. When Congress uses the word shall, it means they don't have an option. Okay? All revisions shall be subject to valid existing rights. So whatever is in that permit, contract, or other instrument, it is subject to valid existing rights because Congress said so. So it must be. There is no choice. They have no choice. When I worked for the Forest Service, they sent out a letter from the chief of the Forest Service addressed to all the regional foresters, and they sent a copy down to us underlings. Okay, and it quoted this section in the National Forest Management Act, Section 6I. Except when I read it, I said, there's something wrong here, something missing. I don't remember this exactly this way. So I went and looked up the actual law, and guess what? Right there, they cut off that last sentence. They did not want anybody that worked for them knowing what the actual law said. They were trying to deceive us. And I went and I read it and I said, oh, any revision in present or future. Does this say some revisions? Any revision. It doesn't matter what. Any revision in present or future permits, contracts, and other instruments made pursuant to that section shall be subject to valid existing rights. Okay? Period. Now, why in the world would the Office of Law Review Counsel leave a whole section of an act out unless they didn't want you to know about it? Well, that's exactly what they did, because you will not find Title VII of the Federal Land Policy Management Act in the United States Code. I'll give you $10 if you can find it, because I've looked and looked and looked for years. It's not there. They don't want you to know about this. And what is this? This is the effect on existing rights, repeal of existing laws, and severability. And the very first sentence says, nothing in this act or in any amendment made by this act shall be construed as terminating any valid lease, permit, patent, right-of-way, or other land use right or authorization existing on the date of approval of this act. So they just grandfathered in every possible existing right that there was as of October 21, 1976. Okay? But they don't have it in the United States Code. This is an act of Congress. Congress passed this law. Signed into law by the President, passed by Congress. This is the law, not the United States Code. All right? And you read through this, all of these savings provisions, and they just sum it all up, really, right here. All actions by the Secretary concerned under this Act shall be subject to valid existing rights. And I've given this to ranchers before, and they've taken it and showed it to their Forest Service guy or their BLM guy, and they say, oh, well, that's easy. You don't have any rights. Really? Okay. So, of course, U.S. versus New Mexico is a very simple answer to that. Okay? If nothing else, we know for an absolute fact that ranchers own the stockwater rights in the national forest, because the United States Supreme Court said so in U.S. versus New Mexico. It's unequivocal. It's absolutely clear. There's nothing ambiguous about it. And when I worked for the Forest Service, I worked for a guy named Dave Stewart, and he was in Region 3 for a long time. And I plopped down a copy of U.S. versus New Mexico in front of Dave Stewart one time, and I said, how about this? The ranchers own the water rights. And Dave Stewart's reply to me was, well, we think the Supreme Court is wrong. Okay. So here, all actions by the Secretary concerned, does it say some actions or the ones that they feel like? No, all actions. And this act also applies to national forests, not just BLM grazing districts. Okay, all actions by the Secretary concerned under this act shall be subject to valid existing rights. There's nothing ambiguous there. It shall be, they shall be subject to valid existing rights. There's no choice. All right, they don't have a choice. So somebody said, well, you know, in my permit it says blah, blah, blah. You know, I talked to Dave Stewart one time. I was talking to him, and he said, I said, we should do this or that or whatever it was we were talking about. And he made a comment. He said, well, we can't do that because ranchers own their allotments. And I said, wait a minute. What did you just say? He said, ranchers own their allotments. I said, what do you mean they own their allotments? I'd always been told my whole life, ranchers don't own anything. They have no rights, right? Isn't that what they tell you? No rights, they don't own anything. I said, wait a minute. I said, how do they own their allotments? He said, well, under these laws that Congress passed in the 1800s, they owned their ranches before there was ever a national forest. Wow, that was a shocker to me. And so I scratched my head and I said, now wait a minute. If they own their allotments, how can we make them do anything? And then he got a big grin and he said, you get them to sign something and then you got them. That's the way he put it. Exactly the way he put it. You get them to sign something, then you got them. Why? They don't take ranchers to court for trespassing on public land. They take ranchers to court for violation of the terms and conditions of the grazing permit. Does that sound familiar? You've heard that phraseology before? That's exactly what they do. You violated the terms and conditions of the grazing permit. Well, that's how Dave Stewart said you get them. You get them to sign something. You get them to sign 20 pages of front and back, fine print, all kinds of stuff you got to do, and then you hold them to it. So you sign this, except for one thing. What did Congress say? All actions by the Secretary concerned under this act shall be subject to valid existing rights. Any revision in present or future permits, contracts, and other instruments shall be subject to valid existing rights. Well, holy crap! That just shoots Dave Stewart's theory all to hell. Okay? This is what you need to remember out of this talk. Whether you're in a national forest, a BLM grazing district, or wherever you're at, you have valid existing rights. And their permits, their plans, their whatever they have, whatever they do is subject to your valid existing rights. Okay, 2 years ago, 2017, in the Sixth Circuit Court of Appeals, the Sixth Circuit Court of Appeals ruled on this section of the National Forest Management Act, and they said absolutely. The Forest Service created a wilderness area, said you can't ride your motorboat in that area anymore. And the guy said, wait a minute, I have prior existing rights, valid existing rights. They predate your wilderness. And he went all the way to the Sixth Circuit, and the Sixth Circuit said, yep, absolutely. You can ride your motorboat anytime you want. Whatever the Forest Service says or does, that's subject to your rights. Those are exactly the kind of rights that Congress intended to protect with this law. Thanks, Hayden. He's the one that sent me that case.
De nada.
So, what are public lands? Where did they come from? All right, in the early days of the United States, there were vast amounts of lands west of the Appalachian Mountains, claimed by both the states and Indian tribes. Some states refused to sign the Articles of Confederation until the larger states that claimed these areas gave up their claims for the benefit, the mutual benefit of all the states. This resulted in Article 4, Section 3, Clause 2 of the Constitution, which says, the Congress shall have power to dispose of and make all needful rules and regulations respecting the territory and other property belonging to the United States. So the territory referred to is public lands. The United States versus Grayshot, 1840, the U.S. Supreme Court ruled that when Congress passes a law using the term public lands, that is what they are talking about. They are talking about the land and other property belonging to the United States. And who has the power to dispose of public lands? Say Congress. Congress, that's right. Okay, it is an exclusive right, what's called a plenary right, that belongs only to Congress. There's three branches of government: legislative, executive, and judicial. The executive department has no say in the disposal of public lands. None. Never have. Only Congress, according to the Supreme Court, only Congress can dispose of the public lands. And when they can do it any way they want. That's what this case was all about. The Supreme Court said Congress can dispose of the public lands any way they want to. They can have a long drawn-out process like the Homestead Act. You got to settle on the land, you got to mark the corners, you got to cultivate it, you got to live there for 5 years, you got to reside there, you got to get affidavits, you got to pay fees. And when you're done doing all this stuff, at the very end it says that some bureaucrat can issue you a patent for that land. Okay? That's one way. Or Congress can just simply pass a law that says the right-of-way for the construction of highways over the public lands not reserved for other purposes is hereby granted. Boom. It's given. It's called a legislative grant. Words of present grant. That's how that Congress can dispose of any way they want. Okay, well here's what it looked like in 1783. As you can see, Massachusetts claimed part of this Northwest Territory, Connecticut claimed part, Virginia claimed part. They all were claiming these lands. Okay, so how was property developed? This is the Lockean theory of property development. The idea is basically, if this was a wilderness and you showed up here one day and nobody was living here, and you cut down a bunch of trees and you skinned them and you limbed them up and you notched them and you stacked them up and you built a house, you have now taken that resource, that object of nature, and you have mixed your labor with it. There is now a part of you, your blood, sweat, your time, you have mixed with this object of nature and you have created property. This was John Locke's theory, and all the land disposal laws in the United States are based on this theory. It runs like a consistent thread through all the land disposal laws. Okay? This Lockean principle of mixing your labor, time, and effort with the land to create property rights predates the Constitution and runs like a consistent thread through all the public land laws. The idea of settlement, appropriation, occupation, improvement, these words are in quotation marks because they're used over and over and over again in all the land disposal laws. Okay, it's consistent with the language of the Agricultural Preemption and Homestead Acts, And at this time, it was illegal to settle on or occupy mineral land. Okay? Prior to 1853, you could not settle on what was classified as mineral land. You could only settle on agricultural land. So if you go back and you look at a map of the United States, everything east of the 100th meridian got rain. You could grow crops. It was classified as agricultural land. And so when people say, why is the West different than the East? Look at the West and look at the East. Why is it so different? Okay, here's the answer. The reason the West is different than the East is because the West is different than the East. Okay? That's why. Okay, the West was considered largely, you know where the mountains are. Lots of mountains. These were considered the mineral land states. And they were also called in acts of Congress the desert land states. There was even a Desert Land Act. Okay? This is how the United States existed in 1783. They didn't have a lot of mineral lands. Okay? And so practically everything was considered agricultural land. So as the West expanded, Congress had to pass new laws. Okay? Okay, so this Act of 1853 was the first of what I'd call the split estate land laws. Okay, now I'll explain why that's important. 1853, that date has a significance. All right, but at the same time, there was a Supreme Court decision right before that, 1839. The Supreme Court said that where Congress uses words of present grant, okay, that is an actual grant. There's no need for a patent. If Congress granted it, then it's granted. Let's see, this is 1831. Okay, this is the second way that Congress granted title documents. Okay, and you can look these up, but in this act, Congress goes through and explains that provided that said decisions, the decisions of the Land Department, and surveys, and the patents which may be issued in conformity thereto, shall only operate as a relinquishment on the part of the United States of all title to land in question. So as Congress was passing laws for the disposal of the public lands, one of the ways that it could be done is if there were two people that had a dispute, they could go to the Land Department and they could argue their case, and the Land Department could then go out and survey the land along the line of wherever either those two guys agreed, and if they couldn't agree, then the Secretary of the Interior or the Land Department at that time would make that decision and would settle where that land would, where that boundary would be between those two claimants. Now this comes into play later on as we go through. Now this is the first grazing law Congress ever passed. Actually it's the second, but the first one was in 1795, and it said you can't graze on Indian land. Okay? Stay off Indian reservations. And this says the same thing, only it's reworded a little bit differently by Congress. It says that if any person shall drive or otherwise convey any stock of horses, mules, or cattle to range and feed on land belonging to any Indians or Indian tribe, without the consent of such tribe, such person shall forfeit the sum of $1 for each animal of such stock. Okay, so this was the first, this was 1834. Okay, so this was the first grazing law. So what's the legal implication here? Okay, what the legal implication, according to the Supreme Court, later in 1890 and in another case in, I think, 1924, the legal implication was it was legal to graze anywhere you wanted except the Indian reservation. So on any place on public land, anybody could graze. I mean, there was even people who made a living at it. Call them free grazers, okay? They just buy a big bunch of sheep and just start herding them across the public land. As long as they didn't get on somebody's homestead or on an Indian reservation or, as you'll see here in a minute later, a military reservation, they could graze anywhere they wanted, and anybody could. Okay, now that didn't give them a right because that was public land, open to anybody. So anybody who wanted to could graze. So in a minute I'll explain where the actual grazing right of an individual, the statute it came under. In this previous case I mentioned, Wilcox versus Jackson. Here's what the Supreme Court said. Nothing passes a perfect title to public lands, with the exception of a few cases, but a patent. So nothing passes title. This is the interpretation that bureaucrats like to give this act is, nothing passes perfect title to the public lands, but a patent. They like to skip over this, the rest of that sentence. But that's not what it says. It says, with the exception of a few cases. The exceptions are, and this is continuation of the quote from the Supreme Court, the exceptions are when Congress grants lands in words of present grant. So when Congress passes a law, like the Act of 1866, Section 8, that says the right-of-way for the construction of highways over the public lands is hereby granted, then boom, it's granted. You don't have to ask permission from a bureaucrat. You don't have to go down and file anything. You don't have to do anything except construct the right-of-way, construct the highway. Which, by the way, the definition of a highway in 1866, when this law was passed, if you go to Bouvier's dictionary, a highway was a place for driving cattle. There was no interstate highways. There wasn't even a transcontinental railroad in 1866. Okay? So, where Congress conveyed land or interest in land by words of present grant, then the legislative act was the grant of title. And the official government survey map that we talked about a minute ago served as documentary evidence of ownership. And this is discussed in detail in this case of Shaw versus Kellogg and Lane versus Watts. The Supreme Court says when Congress passes a law and they grant something, and then they come back and they survey it and they approve that survey map is equivalent to a patent. That is an official government document. Okay? And there's other cases on that same thing. Noble versus Union River Logging Railroad, Morrow versus Whitney. So thus it can be seen that there are two documents that are considered title evidence of ownership to land or interest in land. A patent, or two, a government survey map. Okay? FLTMA protected all of the land use rights granted by acts of Congress. So, here, let's talk Whitney versus Morrow. Here again, the Supreme Court talking about a legislative grant, the effect of a legislative grant. And Congress says a direct legislative grant of public lands is the highest muniment of title and is not strengthened by a subsequent patent of the same land. So an act of Congress making a grant of a right or an interest in the public land is higher than a patent. And if you read that whole quote in there, they say because, I'm paraphrasing here, but they say that because a bureaucrat is subject to corruption. Okay? But whereas an act of Congress says what it says. Okay? So where Congress conveyed land or interest in land by a direct legislative grant, then the legislative act was the grant of title. And the official government survey map served as documentary evidence of the ownership. And this is discussed in detail in this Supreme Court decision, Langdow versus Haynes. So the court said that there was no need to issue a patent, that the act of Congress was more powerful than a patent. Ranchers own their allotments by legislative grant. Okay, so let's back up again. Remember where the United States boundary was, right about here. Okay, Mississippi River, mostly, in 1873. But we acquired Louisiana Purchase. And in 1845, we acquired Texas. A lot of people erroneously think Texas never gave up any public lands. They did. They gave up a huge portion. See this? Right here is where the official boundary is today. They gave up all this land instead of allowing the federal government to have public land within the boundaries of the state. They just gave up a huge chunk of the state. Okay? Oregon country took in Washington, Idaho, parts of Montana, Oregon, and Wyoming. This was acquired in 1846. So in 1845, 1846, 1848, and then 1853, the United States acquired a huge chunk of western land. Okay, and something else happened during that time period, that 8-year time period. In 1849, you might remember there was something called the Gold Rush. Okay, now prior to 1853, could you settle on mineral land?
No.
It was illegal to settle on mineral land. But in 1849, there was this huge California gold rush, and people went there and started claiming land, digging up the minerals. Congress had to respond to that. So in the California Survey Act, 1853, Congress extended a right of occupation only for settlement on mineral lands. Because until they determined whether or not that land you were settling on had gold or silver or valuable minerals in it, they said you only get the surface. Now this was a legislative grant because the act actually said granted the right, and that's what it says, the right of occupation and cultivation under the Act of 1853. The United States increased in size by over a third between 1845 and 53, added Texas, Pacific Northwest, Gadsden Purchase, Guadalupe Hidalgo, in order to encourage settlement while preserving the government's policy of retaining minerals for separate disposal. Congress granted the surface right of occupation and cultivation only to settlers on or near the mineral lands, pending its final disposal. And this is in the Act of 1853. Here's the citation where you can look it up. In the meantime, Kearney's Code, the laws and ordinances of the state of Deseret, which took in about parts of 9 different western states, and the California legislature and Kearney's Code. These all, as a matter of fact, the oldest range law in the West was from Oregon. Before Oregon was even part of the United States, the people in Oregon got together in 1845 and passed their own range code, recognizing range rights. And this was before the Treaty of 1846, where Great Britain ceded the Oregon Territory to the United States. So even before Oregon was part of the United States, they had a range code. New Mexico had a very similar range code, as did the state of Deseret, and then California, they just flat out reenacted as state law the previous Mexican range code. So all the western states had these range codes, these range laws.
Which one is this?
Oh, okay, this is the Act 1853. I just highlighted this part here. It says you cannot settle on mineral lands, except such towns as are located on or near mineral lands, the inhabitants of which shall have the right of occupation and cultivation only, until such time as Congress shall dispose of the same. So in 1853, for the first time now, they open up the mineral lands for settlement, but you could only get the right of occupation and cultivation. If you look up the right of occupation, it means you treat the land as if it's yours. You can do anything you want except what's called despoilation. In other words, you can't come in and just completely destroy the land and rip it up and then leave it. Okay? But you can occupy it, you can cultivate it, you can live on it, it's yours. For all intents and purposes. It's yours for life. Okay? And it cannot be taken away. That's what a right of occupation is. Okay, so we talked about surveying. We'll talk about another law, the Validation Act 1890 here in a little while, but this is the Forest Service Organic Act 1897. And here's what it says. It's actually, the actual name of this law, if you look it up, it's called Surveying the Public Lands. That's the name of it. But for whatever reason, Forest Service decided we're going to call it the Forest Service Organic Act. Okay, but that's the actual name of it. And what it says is preference shall be given in surveying townships occupied. Remember, we just talked about this right of occupation that Congress granted in 1853. Occupied in whole or in part by actual settlers. And then it talks all about the surveying that's going to be done. It's going to make so many surveys, it's going to be returned, and such surveys, field notes, and plats thus returned shall have the same legal force and effect as heretofore given surveys, field notes, and plats returned to the surveyors general. And what did the Act of 1831 say? It is a quitclaim of the title of the United States. When they make that official survey and they return it to you, the government has just said, we just passed our title. It's just passed. And if you look up this act and you read it on further, what it says, if there's two claimants claiming land, then once the government has done their survey and established a boundary, if they have a dispute after that, they got to go to state court. The government, federal government's done with it. They have no more title, no more interest in that. Okay? And this is in the Forest Service Organic Act, 1897. Okay? You can look it up, you can read it. That's why I show these to you. You can go and read. There's a lot of stuff in the law that I did not know as a Forest Service employee because they did not want me to know. They don't want any of their employees to know all this. They want them to follow a certain mindset and to do certain things, and if they told them the truth, then that would get them in trouble because they just might tell a rancher, okay, or tell somebody else, and they don't want them to know this, all right? Congress entered into treaties and agreements settling Indian claims under what's called the Reservation and Assimilation Policy, also sometimes referred to as the Winters Doctrine. Thereafter, they disposed of the public lands to states, railroads, and settlers by this classification system that I told you about, which granted land and interest by a patent or an additional entry or a survey map. Additional entry was another way of acquiring title to land. In 1879, Congress passed a law that allowed for homesteaders to enter what's called an additional entry. Now, an entry is a claim, essentially. It's just a claim. All right, that's what an entry is, but that's what they call it in the land laws. So you can make an additional entry, and there was no requirement for any additional survey, no requirement for the issuance of an additional patent, no payment of additional fees, no requirement for residence, or proofs, entering what were called proofs of cultivation or improvement. In other words, you just had to apply for it. And the only thing you had to do was show that you had a patent for an already existing parcel of land. And then you could get an additional entry. And I'll explain why that was. If you drove around this valley and you looked around this valley and you looked out over the land, you'd see that, oh, here's a house and a little homestead over here in this little valley. And you look over the ridge, oh, there's another one over here. As the West was settled, all the good places were settled up. There wasn't any place left to settle on, except the side of some rocky hill or something. Rocky Mountain. So in 1879, Congress, there was a report issued to Congress that said, we need to be able to give more land to homesteaders. And so Congress passed this act, 1879, called the Additional Entry Act. Okay, now Congress, here's a guy, he's got 160 acres, and his neighbor 10 miles over here, he's got 160 acres, but they're grazing cows out there. And that crappy land in between isn't going to support another homesteader, but it does support their cows. So going back to this act of 1831, Congress said, well, they can just apply for that land as an additional entry of grazing land, and they can decide on where that boundary is going to be. And if you're familiar with the Forest Service or the BLM, they have what they call range boundary agreements. I don't know if any of you heard that term before. Well, they have them, okay? And that's why. Because those people, those guys then decided, well, where is our range boundary going to be? It's going to be between here. And once they decided on that, that's all the evidence they needed other than this official government survey map showing where their allotment was. And you say, well, Angus, you're making a huge leap from allotment or from additional entry to allotment. Well, in the General Allotment Act, 1887, Section 2 specifically says that a grazing allotment is an additional entry of grazing land. So that's where the term allotment comes from. Now, you can go back to the law library at your courthouse and look up the term allotment. There are several different definitions depending on how it's applied. There's financial allotments, there's other kinds of allotments, but in terms of real estate, an allotment is an apportionment of land to someone who by right is entitled to it. That's from Words and Phrases. That's what an allotment of land was. And the term allotment is used in the land disposal laws all the way back to 1795. Okay, so it's not a new term. The Supreme Court said in a case, I'd have to look it up. I can't remember what it is right now. It's, but I can look it up if you want to know it at the end of this thing. But the Supreme Court has said that an allotment is analogous to the term homestead. They both mean the same thing. Okay, so whether you call it a homestead or allotment, means the same thing. Okay, so Congress entered into treaties with the Indians, okay, additional entry or survey map. Okay, here's a quote from Barton versus Northern Pacific Railroad, 1892. And you can go to justia.com. You can write that down, Justia. Type in the name of any court decision you want to see. Type it in, hit the little search button, and it'll pull it up. Okay, and you can read it for yourself. But here's what the Supreme Court said. By public land, as it has long been settled, is meant such land as is open to sale or other disposition under the general land laws. All land to which any claims or rights of others is attached does not fall within the designation of public land. In other words, if someone else has already claimed it, it's no longer public land. Okay? There's a right attached to it. Okay, here's another U.S. Supreme Court decision, Utah Division of State Lands versus U.S., 1987. So this is an ancient law. Okay, 1987, not for me, maybe for some of you youngsters, but not for me. Okay, and here's what the Supreme Court said. Most enduringly, public lands have been defined as those lands subject to sale and other disposal under the general land laws. So if it's not available for disposal, it's not public land. They can call it public land all day long. They can call it public land till the cows come home. Okay, as they say. But that doesn't make it public land. It is not legally public land. It doesn't meet the definition. Okay, and that's why 9 times out of 10 ranchers get screwed when they go to court. Because the first thing they want their lawyer to do, and Hayden can tell you this, is they want you to stipulate. What do we agree on? We agree that this case is about grazing on public land. If your lawyer agrees to that, you just lost. You might as well give them a bunch of money and then just walk away, because you're already done. Okay? There is no right to graze on public land. Once you claim that land, once you claim it, it's no longer public land. And the thing that the land department used to determine a valid claim was the question, is the land enclosed? If it's enclosed, and that's using either a fence or natural barriers and fences together, constitutes an enclosure of the land. And once you've enclosed it and you've improved it, now it is no longer public land. It is what the courts have called occupied, unpatented land. Okay? So, beginning in 1853 and culminating in 1890 was what's called the Validation Act, and we'll talk about that in a minute. Congress adopted a split estate land disposal policy that clarified the definition of public land. From 1910 to 1920, Congress enacted several dozen remedial statutes to clearly incorporate this policy into the agricultural land laws. And you can read about this in this case of Watt versus Western Nuclear, where the U.S. Supreme Court explains that for very long, from 1866 forward, Congress had followed this split estate land disposal policy. Now, you go back and you read the Act of 1866. Go back and read it. The Act of 1870, the Mining Act of 1870, was an amendment, and it says so right in it, to the Act of 1866, and so was the Mining Act of 1872, an amendment to the Act of 1866. So those 3 laws are what is referred to as the mining law or the mineral land laws. And you go back and you read that, and no less than 12 times you're going to find the phrase surface claimant, surface claimant, surface claim. That was intended very clearly to be a split estate law. The Act of 1872 repealed Section 1 of the Act of 1866 and created a new section. And that section says that the public lands of the United States are hereby open to exploration and development. No, it says the mineral deposits. The mineral deposits in the public lands are open to exploration and development, and the land is open to occupation and disposal. 2 clearly separate things. The mineral deposits are open for exploration and development, and the land to occupation and disposal. Okay, that's what it says. That was the whole purpose, was to create a split estate. I don't know if I have it on here. Well, Barden versus Northern Pacific Railroad. There you go, 1894. Justice Field very clearly says, hey, Congress intended to make a split estate when it passed these laws. Okay, so, but you can read in Watt versus Western Nuclear, the Supreme Court explains, hey, this was a long-standing policy of Congress. Congress decided in 1909 that they were going to fully adopt the language into all the homestead laws. And so they did. They began in 1909, and between 1909 and 1916, when Congress adopted the Stock Raising Homestead Act, the Supreme Court says in Watt versus Western Nuclear that Congress fully adopted this split estate land policy. And that from that date forward, there was no land granted that the surface owner acquired the mineral rights. The mineral rights were retained to the United States. Okay? So again, here's the definition of public lands. I'll just show it to you right here. This is the exact same thing. This paragraph here, Federal Power Act of 1920, Volume 41, Stat 1063. There it is. Volume 41, page 1063. Public lands means such lands and interest in land. Now, after 1916, Congress had to change the definition. It was no longer just land, because now they'd created a split estate. So now it was land and interest in land. And the interest in land retained by the United States was the mineral rights and the commercial timber rights. Okay? So now, public lands, this is right out of the law. Okay? And it says, public lands means lands and such interest in lands owned by the United States as are subject to private appropriation and disposal under the public land laws. It shall not include reservations as hereinafter defined. So what are reservations? Reservations means national monuments, national parks, national forests. National forests are not public lands. Congress says so. Okay? Tribal lands embraced within Indian reservations and other lands and interests in land owned by the United States and withdrawn, reserved, or withheld from private appropriation or disposal under the public land laws. Okay? So, in 1877, this is where the huge shift came. Slightly following the Grazing Rights Act of 1875, which we'll talk about here in a minute, this case of Atherton versus Fowler came down. This guy bought a big ranch. He thought it was a perfect title. He thought that he owned it. It was a Mexican land grant. It turned out that the land grant was void. All the I's hadn't been dotted, the T's crossed, and whoever was supposed to sign it didn't sign it. So overnight, this huge ranch that he had became quote-unquote federal property, right? Belonged to the United States. And so all these people started moving on there to homestead, claiming it under the preemption law. And it took him a year to get all those people evicted off of there and to get to the Supreme Court. While one of those homesteaders was on there, he cut all the guy's hay. Okay? Remember, this is grass growing on land, the legal title of which is in the United States. So the guy cuts all the hay. He goes to the Supreme Court, sues for what's called repleveling to recover for the value of the hay that this homesteader cut off of there. So, and this is what the Supreme Court said. It follows that the later settlers, those later homesteaders that tried to homestead on there, could not have made any lawful entry on the lands where the hay was cut in this case. That no law existed which gave them any right to make such an entry. That they were mere naked trespassers, making an unwarranted intrusion upon the enclosure of the earlier stock raiser, an enclosure and occupation of years, on which time and labor and money, okay, remember you mix your labor with the land to create property, had been expended, and that in such a wrongful attempt to seize the fruits of other men's labor there could be no bona fide claim of right whatever. The instruction of the court that this could be done, founded on an erroneous view of the preemption law, was itself erroneous, and the judgment founded on it must be reversed. And further on in that case, the Supreme Court said, Atherton was the only person who could get title at land. For all intents and purposes, he was the owner. And all that was left was for him to acquire the legal title from the United States. He had what the Supreme Court called a preference over all other persons on the planet Earth. Okay? And this was in 1877. Okay, so the forge, the improvements, the structures, the practices developed and permanently placed on the land were property, even before the United States legal title vested in the settler. The Fifth Amendment to the Constitution states, no person shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Therefore, the government must give due process and just compensation to stock raisers for improvements, including forage crops, grazing value. That language comes from specific acts in 1929 and 1949, even when exercising constitutional power. So even if the United States government has a constitutional power, say, to build a dam for irrigation, they can do that. So even though they're exercising a constitutional power, they can't destroy or take private property. So if they build a dam and it floods your ranch, like it did this guy in Wyoming, in Bothwell versus United States, the federal government still has to pay you for it. Okay? So through a series of statutes passed in the 1800s and 1900s, Congress authorized, validated, and granted split estate property rights to settlers in the arid mineral region west of the 100th meridian. This comes from the Validation Act of 1890. Okay, the land in the west was arid, so physically different than the east that Congress established two separate land settlement patterns. The conditions to accommodate the conditions in the west. This is talked about in this case right here. California versus U.S. This is not ancient. This is 1978. Okay, and in Watt versus Western Nuclear, 1983. Okay, so Rehnquist wrote the opinion in both of those cases. All right, it's very astute. He explains it, explains the laws that created it, this settlement pattern. And here's really the real reason. This is from 1879 report, John Wesley Powell's report. See these little black dashed lines, isoets, okay? They show precipitation zones. And the 30-inch precipitation zone just happens to lie right along the 100th meridian. So there was a reason why Congress passed two different sets of land disposal laws. Because the land west of the 100th meridian got less than 30 inches of rainfall, and even Congress knew that without irrigation you couldn't grow any crops west of the 100th meridian. And so that's why they passed that law. And it's called, and this is all discussed in that California versus U.S. case that Rehnquist wrote. He explains all this in detail. In the East, okay, in the East, they had riparian doctrine, riparian law. In the West, prior appropriation doctrine. So there's two legal doctrines of water law in the United States. Prior appropriation doctrine, riparian doctrine. This is according to Rehnquist. Okay? Why? because the east is different than the west. Here's all your navigable waterways. Okay, have you ever heard the phrase waters of the U.S.? What that refers to is the navigable waters of the United States that are usable for interstate commerce, because that's where the government's power comes from to regulate, is the Interstate Commerce Clause. All right? So under the Interstate Commerce Clause, they could regulate interstate commerce on all of these navigable waterways. Remember where that 100th meridian was? See this eastern boundary of the Texas Panhandle? Goes right through Dodge City, Kansas, right down Main Street, all the way up and follows the Missouri River as it runs north through North Dakota. That's the 100th meridian right there. And west of the Missouri, west of the 100th meridian, is the prior appropriation doctrine states. There's only one navigable river west of that line. That's the Columbia River from the Idaho border to the Pacific Ocean. This is where all the navigable rivers are. Okay, that's where the waters of the United States are. Does this map look familiar? You look at where's the 100th meridian? By golly, there it is. It runs right along the Missouri River, right down through the Texas Panhandle, right there. Okay, so very little. As a matter of fact, most of this land in the west, or the east, I mean, that's in national forest, is purchased land. It was purchased under what's called the Weeks Act in 1911. There's actually two different, completely different forest services in the United States. All of these national forests east of the 100th meridian, most of them, not all of them, some of them were reserved, but 99% were purchased land, and they were purchased under the Weeks Act for flood control of these navigable rivers. They were the headwaters of all these navigable rivers. Okay? But in the west, that land was settled under a completely different settlement pattern and different set of laws. The Act of 1866, which recognized prior appropriation water doctrine. So the prior appropriation water doctrine was developed in the West, had its basis in Spanish law. This is Kearney's Code. It's still the law in New Mexico. Laws heretofore enforced concerning water courses, stock marks, brands, etc., shall continue in force. Okay, it developed in areas where water was scarce, when irrigation, stock watering, and mining were dominant uses, under a legal system that recognized the first person to put water to recognize beneficial use, regardless of whether they own riparian land, acquired a superior right over later appropriators. This is actually out of the current and the long-standing Arizona State Constitution. Riparian water rights, Section 1. The common law doctrine of riparian water rights shall not obtain or be of any force or effect in the state, period. It's pretty straightforward and clear. And when people tell me, well, the Forest Service guy told me my riparian area sucked, I said, well, tell him that he is wrong, because you do not have a riparian area. The Supreme Court has said the riparian doctrine applies in the eastern part of the United States, east of the 100th meridian. Okay? So, by the Act of July 26, 1866, 1870, and the Desert Land Act of 1877, all discussed in this Supreme Court decision by Justice Rehnquist, okay, severed the water from the public lands. And the Act, August 30, 1890, they established the 100th meridian as the federally recognized boundary of the desert land states by reserving rights of way for ditches, canals on all lands patented after that date. As a matter of fact, there's a story behind the Validation Act of 1890. Several things were going on in the country. The Johnson County War in Wyoming, people were being killed. The Wyoming stock growers brought in 50 hired gunslingers from Texas, a special train. They had a hit list of 70 actual ranch settlers that they were going to kill. Okay? This is all historical fact. It was on the front page of the New York papers and the Chicago papers at the time. And this was going on at exactly the same time period. People in the West were being murdered over range rights. What I would call globalists today, wealthy, extremely wealthy individuals, people that were invested in the railroads, in the mining companies, these people would come out west. They were even foreigners, foreign, high-born aristocrats. They would come out west, they would buy a range operation. Remember, it was legal for anybody who wanted to let their cattle or sheep graze on the public land. Until someone actually claimed it and enclosed it, it was legal for anybody who wanted to graze on the public land. All right, so these people came out, they didn't bring out 1,000 head, they'd bring out 10,000, 20,000 head of cattle at a time, turn them loose on the range. And all these pesky homesteaders, these actual settlers, okay, that would try to take up homesteads were getting in the way. And they hired 50 gunslingers from Texas to come out up a literal army to exterminate 70 different homesteaders. Okay, that's what the Johnson County War was all about. It's all historical fact. You can go look it up. But this was going on, and they were hanging people, lynching them, women even. Okay, this incensed the public. Okay, outraged the public. And so Congress, at this same time, John Wesley Powell had this great idea. He said, if we could only dam up every creek in the West, we could irrigate the whole West. Okay, it was pie in the sky. It wasn't going to work. They soon found out. But at the same time, Congress passed a law which withdrew all the unpatented land in the West from settlement. Well, this caused a furor, because by 1888, the West was largely settled. Pretty much largely settled. So this would have deprived every rancher around here of what's now their grazing allotment. So Congress, when they got this backlash, and then all this stuff hits the news about these big globalist cattle barons trying to murder homesteaders in order to keep the land unfenced. They wanted it to remain, quote, public land. Why? Because as long as it's public land, they could graze as many cows as they wanted out there. So that was their goal, but this caused a huge furor. And so Congress immediately acted and passed what's called the Validating Act of 1890. And in that act, Congress said all occupancy, entry, and settlement west of the 100th meridian, and that's why they used the 100th meridian, is hereby validated. Now, when Congress validates a claim to public land, that's the end of it. When they say all occupancy, entry, and settlement is hereby validated, bam, that's it. They just legalized every entry in the West. So, anyway, that was the importance of the Act of August 30, 1890. Okay, so 1885, oh wait a minute, this is 1875. This is the Grazing Rights Act. Okay, I call it the Grazing Rights Act. The actual name of it is an act, well, it's on the other page. This is the top paragraph is this part here on the other page. But the actual title is an act to protect ornamental trees and for other purposes. Okay, some of these acts had weird titles, okay, that don't tell you anything about what's in the act. But the act actually made it unlawful for anybody to enclose more, or to graze, excuse me, to break through a fence, to graze on any military reservation. And that's what this says. It says, if any person or persons shall knowingly and unlawfully break open or destroy any gate, fence, and it says hedges and walls and stuff, destroying grass or trees, or where said cattle, horses, or hogs may or can destroy the grass or trees, shall pay a fine or be in prison, provided, and this is the important part, provided that nothing in this act shall be construed to apply to unsurveyed public lands and to public lands subject to preemption and homestead laws, or to public lands subject to an act to promote the development of the mining resources of the United States. So what this says is it's illegal to graze on a military reservation, but if the land's open for homesteading or the preemption laws or the mining laws, it's legit. You can graze on those lands. And from that day forward, the land department interpretation was that grazing was equivalent to cultivation or mining. You guys know right now, I don't have to tell you, but you know of land around here, maybe 160 acres somewhere, some homestead, that has never been cultivated. It's never seen a plow. The only thing that was ever done to it was grazed. And that satisfied the requirements of the homestead law. So grazing, as of 1875, became a means of acquiring title to land in the West. So under the series of statutes that Congress passed, a whole series of statutes in 1853, Congress granted the right of occupation. These were all statutory grants where Congress just passed a right and it said you have a right of occupation and cultivation. You have a right to do this. You have a right to do that. So there was a whole list of these statutory grants. Okay? The right of occupation, cultivation, to acquire water rights under state law, to construct ditches, canals, and roads under these particular acts, to construct reservoirs, pipelines, and flumes under this act. State possessory property rights were recognized under this act, 1873. Improvements under the Act of 1874. The right to construct improvements on the public land and be compensated for it if that land was ever given to anybody else. Okay, timber use rights. Okay, 1878. That the court said was an absolute grant of the right to cut timber on the mineral lands of the United States. Now, I remember in 1866, the Supreme Court said Congress adopted a split estate policy for the mineral lands. So all land that was considered mineral land, you could acquire the surface to, because it said so, surface claimant, okay, but you could also cut the timber, all right? So you had an individual right to cut timber. There's all these rights that Congress passed, legislative rights. I'm going to speed it up here a little. Okay, so this is the Act of 1885, an act to prevent unlawful occupancy of public lands. This was designed to stop all these foreign and eastern cattle barons from fencing in land and keeping ranchers off. Okay, they said it was illegal to fence in more than 160 acres, except, it says provided, this section shall not be held to affect the right or title of persons who have gone upon, improved, or occupied said lands under the land laws of the United States, claiming title thereto in good faith. So what were the land laws of the United States? All these laws that I just named off. Okay? So, the Act of 1853 opened all the mineral lands by words of present grant. Had granted a right of occupation and cultivation only. The Mineral Land Acts of 66, 70, 72, 73, and 75 It recognized as valid water rights, state and territorial land titles pertaining to grazing rights, and this is discussed in this case of Griffith versus Gotti in 1885. This decision followed shortly after this act of 1885. Okay, so following the report of the Public Lands Committee in 1880, Congress enacted a Relief Act that removed acreage limitations on settlers' land claims. Also, in this case, the Smelting Company versus Kemp, Justice Field explained that, oh, these laws that say that no person can acquire more than 160 acres, what that means is no person can. But if two people acting together, because how are most ranches in the West established? Usually ranchers, several homesteaders were grazing together, right, in common. And eventually they divided it up under the act, that Survey Act 1831, divided up into individual allotments. Okay, does that make sense?
Yeah.
Throw something at me if it doesn't. Okay, so, and this is what justice, now if I had told somebody, well, that law that says no person can acquire more than 160 acres, well, that only means a person. But if two people got together, they can acquire any amount of land that they want. If I had told somebody that, they'd say, Angus, you're full of crap. You're dreaming. You're making this crap up. Well, that's exactly what Justice Field said in this case. So you need to go and read that case for yourself. He explains, no. The whole purpose of that land restriction under the homestead laws and these other laws that limited the amount of land was to prevent a single person from monopolizing a huge area of land. But if two or more persons in an association together decided to claim a large area of land, and one of those homesteaders eventually bought out the other one, and then eventually became the owner of the whole area, there's nothing in the law that forbids that. So that case right there explains how the West was settled in these grazing allotments. The Act of March 3rd, 1890, okay, the Validation Act. It validated, because there was this huge perception on a national level that there was a bloodbath occurring in the West. People were killing each other over land titles, land disputes. Congress said, we're just going to settle all this. All occupancy, entry, and settlement as of August 30, 1890 is hereby validated. Well, this changed everything. Now, everything in the West, there was hardly any, quote, public land left. Why? Because everything in the West was occupied, entered, or settled on at that point in time as a ranch. So now Congress had to change all the laws. So they passed what is called the General Land Law Revision Act, except that the Forest Service calls it the Forest Reserve Act. Because out of 23 sections in that law, there's one section, section 23, that says the president can create forest reserves. That ignores the whole rest of that act. The whole purpose of that act was to confirm and establish a new way of disposing of the land in the West. That was the whole purpose of the Act of 1891. Okay? And in later legislation, you can go home and look it up. Get on the internet, type in General Revision Act and see what comes up. Because that's how Congress referred to it for many years thereafter. They never referred to it as the Forest Reserve Act. That didn't happen until the 1940s. And the Forest Service started calling it the Forest Reserve Act. Okay? But so once Congress validates a right, it's perfected. You can look in this case of Basie versus Gallagher. The Supreme Court explains that. 6 months later, Congress enacted the Forest Reserve Act. See, I'm even doing it. I'm calling it the Forest Reserve Act. It's actually was referred to as a General Land Law Revision Act, but that's shorter to call it Forest Reserve Act. Okay, the fact that ranchers pay grazing fees contributes to the misconception that ranchers have a leasehold. However, the grazing fee is not a rent. The grazing fee goes to three things. 25% of the grazing fee goes to the state or county of origin for roads and schools. That's under the 25% Fund Act, 35 Stat 251. You can look it up. Okay? 25% is an administrative charge for what? For making maps. They do surveys. Okay? They do surveys, they record things. It's an administrative charge. So 25% goes to the bureaucrats. And then the other 50% is a voluntary, believe it or not, voluntary refundable contribution. That's exactly how it's referred to in the Cooperative Improvement Fund Act of 1914, found at 38 Stat 430. You can go look it up. Why? Because Congress had just validated all occupancy, entry, and settlement west of the 100th meridian. Section 1 of the Act of 1891 gives the Secretary of Interior 2 years to confirm all land titles that were just validated by Congress. So they got 2 years to confirm them all, and later on in that same act, further on, it says that the Secretary of Interior has 5 years to contest any title perfected under that law. Otherwise, they would be forever barred from challenging that title. And there's at least 3 U.S. Supreme Court cases on that. Okay? So, ranchers own their allotments. The bureaucrats were in deep doggy-doo. Now what are they going to do? They're going to be out of a job, so they had to think of something for them to do. Well, you know, the government retained the mineral rights, so they need to keep some around to administer their mining program. And they kept the commercial timber rights. So they needed to keep around a few foresters to have those timber sales. Okay, but darn, how do they control the ranchers? Well, they can't. Well, let's invent this cooperative improvement program. If they contribute money to this program and they sign on to it, then we can build fences to them and we'll have jobs. And that's exactly what they did. Okay? Here's just a list of some of the Supreme Court cases that say ranchers own their range. They are property owners. That's a few of them. This one's, I think, is the most important. Kern versus Benson, 1911. This guy had a ranch, been there a long time. The government draws a big circle and takes half his ranch and says, this is now Yosemite National Park. And you can't graze in the park without a permit. And he says, yeah, I can. And so he goes all the way to the U.S. Supreme Court, and the Supreme Court says, yeah, he doesn't need a permit. His rights predate your national park. He doesn't need a permit. The decision was unanimous. All the Supreme Court justices agreed. Now, what the Forest Service was trying to do was that same year, just 6 months before, that same year, there was a tramp sheepman. He did not own water rights under the Act of 1866. He did not own improvements under the Act of 1873. He did not have any rights whatsoever. He did not have a homestead. He did not have an additional entry of grazing land. He was just a tramp sheepman. He'd buy a big band of sheep and just start herding them across country. Well, he goes through the Sierra Forest Reserve in California, and the Forest Service says, oh, you can't graze in the forest without a permit. So it goes all the way to the U.S. Supreme Court. The Supreme Court says, oh, this guy, he's got to have a permit. Unanimous decision. Okay? At the same time, they heard a case from Colorado of a guy who he'd turn his cows loose and they'd wander and get about 30 miles away from his home ranch, off of his home range and into the White River Forest Reserve. And the Forest Service said, oh, if you're going to graze in the forest, you got to have a permit. And the guy said, well, this is a fence-out state and it's unconstitutional for the government to own land, and every other argument you've heard for the last your whole life. Okay?
Yeah.
And the Supreme Court says, no, if you're going to graze in the national forest, you got to have a permit. But the interesting thing about this case, the second case, Light versus U.S. Fred Light was a rancher. He had a ranch. He might have had water rights. He might have had grazing rights. But the very first thing the solicitor says in his argument, he says the appellant, Fred Light, has no right to challenge the forest reserve or the reserve policy of having to have a permit because he claims no prior existing rights. You see? You see the difference? Less than 6 months later, J.B. Curtin goes to the Supreme Court. He says, I got 23,000 acres of range rights. I own patented lands. I have rights under the Act of 1866. And I don't need no permit to use my property. So you may call it a national park, but my rights pre-exist the national park. And the same 9 justices that ruled against Pierre Grimaud, the tramp sheep man, and Fred Light, who did not claim any rights, now those same 9 justices that ruled unanimously against them now completely flip and rule unanimously in favor of Fred Light. And what was the only difference?
Prior existing rights.
Prior existing rights. He had valid existing rights. He knew what his rights were and he asserted them, and that is the difference. So, here's an example. Some homesteader would come out here and he'd homestead, and then another homesteader might come out here and homestead. Okay, and maybe they'd run their cattle out here and they'd appropriate water rights, and maybe they'd put some pipelines and drinkers, and maybe they'd drill a well. Okay, they'd now they had rights under not only the Act of 1866, but they had grazing rights under the Act of 1875, and under the Act of 1866, and under the Desert Land Act. For every stock water location, they could claim a 640-acre stock water location. And remember, in that case of Smelting Company versus Kemp, the Supreme Court said that you could have an unlimited number of locations to make up your claim. If it was 2 or more people associated together. So if this was a range where there was 4 or 5 or 6 ranchers that all grazed together, they could claim. Or if it was a range that had 2, they could claim the range, and there was no acreage limitation. So you could have any number, unlimited number of 640-acre stock water locations. Okay? Under the forest, under the Act of 1873, you could build improvements. And under the Act of 1885, if you built these improvements and enclosed your range, it was perfectly legal to do so. And there's a Supreme Court case on that, Cameron versus U.S., 1893. The purpose of the Unlawful Occupancy Act, 1885, was to keep those big cattle barons from claiming land, not to prevent actual settlers from claiming land. As a matter of fact, that law said that that law did not affect anyone who had a claim under any of the land laws in the United States. So these ranchers then might decide, well, you know what? I don't like you. Let's just fence off. I don't like your bulls, so I'm going to fence off my piece of the range. So then they, under that Act 1831 and Section 8 of the Stock Raising Homestead Act, either one, those two between themselves could decide where they're going to split their land at. So they did. Okay? And then they had a right to construct improvements, wagon roads and other improvements under the Forest Reserve Organic Act, 1897. And under the Act 1870, under the Act 1866, Section 5 and Section 13 of the Act 1870, Congress said that state law could apply to surface claims under the mining laws. And so a lot of states, not New Mexico, but Arizona and Idaho and Nevada and California had a range law that said you could not graze within a certain distance of somebody else's stock water. Okay, New Mexico didn't have that law, neither did Montana or Oregon, or who am I leaving out? Or Utah, I think. Utah, yeah. So, but some of these states, you couldn't graze within a certain distance. Okay? So you can see that all of these various rights that Congress granted over time kind of added up together to create this split estate property right that ranchers had. So by 1890, when the Validation Act was passed, this is what the West looked like. Ranchers had legitimate claims to their grazing land. Okay? So here's basically a summation. By 1909, so many property rights exist in the West that in his final report to Congress, President Teddy Roosevelt stated, rights to the surface of the public land be separated from rights to the forest upon it and to minerals beneath it, and these should be subject to separate disposal. And this was cited to by the Supreme Court in Watt versus Western Nuclear in 1983. Okay? So, but to top it off, by is this 1912? Which one is it? Yeah, this is 1912. The Forest Service, being resistant as they were, fought tooth and toenail against recognizing ranchers' property rights. So in 1912, Congress passed a law that said the Secretary of Agriculture is hereby directed and required to select, classify, and segregate as soon as practicable all lands within the boundaries of national forests that may be open to settlement and entry under the homestead laws applicable to national forests. Congress ordered the Secretary of Agriculture to dispose of all land in national forests. The following year, 1913, they passed this law to make it happen, that hereafter, when public lands are excluded from national forest or released from withdrawals, the President may, whenever in his judgment is proper and necessary, provide for the opening of the lands by settlement in advance of entry, by drawing, or by such other method as he may deem advisable in the interest of equal opportunity and good administration. Only to homestead entry by actual settlers, only or to entry under the desert land laws for a period not exceeding 90 days, the unentered lands to be thereafter subject to disposition under the public land laws applicable thereto. Makes it pretty clear. Congress said dispose of all the land in national forest. Well, how can that be? Because we still have national forest. It's a split estate. They disposed of them as a split estate. That's why these ranchers can buy and sell these allotments, and they have for the last 100 years. And the government has never opposed them. But in order for the bureaucrats to keep control of that rancher, they had to have something to hold over them. And it's just like Dave Stewart said, you get them to sign something. So the next year, 1914, you remember what Congress passed? Cooperative Improvement Fund Act. Yeah, you get those ranchers to sign up for that Cooperative Improvement Fund. Get them to sign up. Okay? And that's how they get control. Did J.B. Curtin need a permit? No, he didn't. Okay? This is what it looks like. Let me get to, okay, I want to show you this map. This is published in 1902. Albert F. Potter developed this map. This was the first classification map of all the grazing land in the West. This is an official government document published in a report by Congress. So I actually have this on, I scanned it all and have it electronically. This is so detailed, you could zoom into it and you could find your allotment on here. If you could zoom in, it's that detailed. And it shows, it's hard to tell from this size, but it shows where all the year-long range was, the summer range, what was classified as spring range, as summer range, as winter range. It's got all those classifications on there. So, and this was 1902. Okay, so by 1902, Congress very clearly recognized that grazing was a legitimate activity on all the lands in the West. That's some endangered species stuff we're going to skip over. So we're going to talk about in a criminal prosecution or civil action by the United States for trespass on such public timber. Remember I told you the Forest Reserve in U.S. versus New Mexico, forest reserves are established for two purposes. To provide a continuous supply of timber to meet the needs and necessities of the settlers of the arid West, and to enhance water flow in order to make that water available for private appropriation. Okay? But, so what was reserved? The commercial timber and the minerals. That was what was reserved. The surface was granted to the rancher, and here's what Congress said. In the 1891 so-called Forest Reserve Act, the General Land Law Revision Act, in any criminal prosecution or civil action by the United States for a trespass on such public timberlands, or to recover timber or lumber cut thereon, it shall be a defense if the defendant shall show the said timber was so cut or removed from the timberlands for use in such state or territory by a resident thereof for agricultural or mining or domestic purposes and has not been transported out of the same. So it is a defense. So if you ever get charged with, oh, you're illegally cutting timber, if you can show, hey, I was just cutting it for my own use or my use of my neighbor right here within the state, you're off the hook. This is still the law. This hasn't changed. The Forest Service might want you to believe so, but they want you to believe that you're also grazing on public land. Okay? The jurisdiction. This is in the 1897 Forest Service Organic Act. The jurisdiction, both civil and criminal, over persons within such reservations shall not be affected or changed by reason of the existence of such reservation. This is forest reserves. Except so far as punishment of offenses against the United States therein is concerned, the intent and meaning of this provision being that the state wherein any such reservation is situated shall not, by reason of establishment thereof, lose its jurisdiction, nor the inhabitants thereof their rights and privileges as citizens, or be absolved of their duties as citizens of the state. So the state doesn't lose any jurisdiction. You don't lose any of your rights just because they create a forest reserve. And the only thing they can punish is what's called offenses against the United States. What's an offense against the United States would be, are you mining without a permit? Are you cutting commercial timber without a permit? That is what an offense against the United States is. Because what did they reserve? The timber and the minerals. Here it is again, almost the exact same language. This is in the Weeks Act of 1911. Almost exact same language. This is in 1936, okay? Right after passage of the Taylor Grazing Act. That the acquisition by the United States, and see, the government was going out buying up land that had failed during the Depression, the Dust Bowl, putting it into what's called national grasslands. Okay, so Congress passed the same language here. This is kind of long, but it says that, that any land that they had bought for resettlement administration, emergency relief, etc., or any other law shall not be held to deprive the state or political subdivision thereof, the county, of its civil and criminal jurisdiction in and over such property, or to impair the civil rights under the local law of the tenants or inhabitants on such property, and insofar as any jurisdiction has been taken away from any such state or subdivision, or any such rights have been impaired, jurisdiction over any such property is hereby ceded back to such state or subdivision. Congress wanted to make it absolutely clear that they were claiming no jurisdiction whatsoever. There's a lot of this land acquired in these national grasslands, and there's no jurisdiction. So even when the government bought the land, the intent was not to assert jurisdiction over it. The whole purpose of them buying that land was resettlement. All those homesteads that failed were too small. So they bought up a bunch of land and then they gave it, granted it, whatever you want to call it, to allotment owners. Nearby ranchers that already had a ranch, they would give them that additional land as a grazing allotment. And it was under an agency called the Resettlement Administration. That's what it says right here. It says Resettlement Administration. The whole idea was to buy that land, wasn't to keep it, but it was to resettle it in a large enough quantity that it could support a family. And right here they're saying, hey, we have no jurisdiction. If anybody thinks we have jurisdiction, we're giving it back. The state has a jurisdiction. We did not buy this land to acquire jurisdiction. Said the same thing in the National Forest, same thing in the Taylor Grazing Act. I don't think I put the Taylor Grazing Act up there, but it has the last section, section 16 of the Taylor Grazing Act, says the exact same thing. Okay? I'll have to add it on there. Here's another evidence. It's arson. If you set a national forest, national park, Indian reservation, so on and so forth, this act has like 20 different things. National parkway, recreational area, seashore, lakeshore, cemetery, recreational demonstration project, wildlife refuge, grazing district, or stock driveway, or so on and so forth. If you set fire to anything, you're going to get in trouble. Except unless an allottee sets or causes to be set any fire in the reasonable exercise of his proprietary rights in the allotment. Everybody else is going to get fined $5,000 or in prison for not more than 5 years, except unless you're an allottee. Why? Because you are the owner. You own your allotment. Okay, so this is what we started with. This is what we're ending with. All actions by the Secretary concerned under this act shall be subject to valid existing rights. But if you don't know what your rights are, and you show that piece of paper to the bureaucrat, what's he going to say? Ah, you ain't got any rights. Because they're ignorant. They don't know. They don't teach us. There's no Forest Service school that says these are ranchers' rights. They don't want them to know. They want them to think, oh, these are all public lands. All of these lands are public lands. There's no rights out there, none. Put on your blinkers, just do what you're told, be a good little robot. Okay? That's what they wanted me to do. I am actually a retired USDA PhD rangeland management specialist. So I know what they're doing. As soon as I could take retirement, I took it. But the whole time I worked for them, every time I tried to stick up for a rancher, it was like they were trying to chop my head off. I even had to go to court. They fired me one time for sticking up for a rancher. I had to go to court. I had to hire a lawyer. I know what it's like to go up against these guys. I had to go to court because I turned them in for misappropriation of the Range Betterment Fund. They were using that money in the state of Arizona. Dave Stewart was part of it, using that money to file on your water rights. File on ranchers' water rights in the name of the United States. Now, if they'd been using that money to file on their water rights and put it in the name of the rancher, that might be legit, but they weren't. They were filing on it in the name of the United States. So I turned them in, and the day before, 5 o'clock, the day before we were supposed to go into court with my attorney, the government comes and they say, let's make a deal. We don't want to go to court on this. So my lawyer made a deal. And I said, this was almost 30 years ago. If I knew then what I knew now, I wouldn't have made the deal. But I was just barely learning these things. And my lawyer also said, hey, we can fight them if you want, but I want another $10,000 up front. Okay, and I said, well, I ain't got that. So they made a deal. So I got everything back that they denied to me, promotions, etc. and everything, back pay, but I had to drop my case against them. Okay, so I know from firsthand experience what these people are capable of. I know it's not easy. It's easy for somebody to stand up here and say, you should just stand up for your rights. I know it's not easy because I've been there and I've tried to stand up for other people's rights. Okay? But there comes a point in time when you become aware of what your rights are, and now you have to make a choice. So I'm going to ask all you who have not joined the Range Allotment Owners Association, I'm going to ask you to join us. You can go online, rangeallotmentowners.com. You can sign up online. It's very expensive. It's $50. Okay? But you know what? It'll be the best $50 you ever spent. And we work with, I have to say, I'm going to brag on him. He's new at being a lawyer. But we've got Hayden Ballard here from Utah, came all the way down here to be with us here. And he will fight for your rights. All right? So you have rights. all actions by the secretary concerned under that act, under FLTMA, and that's what they cite all the time. Oh, FLTMA says this. Oh, we can't do that because FLTMA says this. Bull. Crap. All right? All actions by the secretary shall be subject to valid existing rights. You own your allotment. They don't want you to know it. They want you to knuckle under. They will threaten, they will cajole, they will wheedle, they will do anything to get you to sign that permit. And do not change one word on that. You sign that permit and you don't change one word. Wait a minute. Wait a minute. Why do they need you to sign that permit? If you have no rights, why do they need you to sign that permit? If you have no rights, it doesn't matter whether you sign that or not. You got to do whatever they say if you have no rights. The whole reason they want you to sign that thing is because you are giving them the authority to manage your allotment. You are agreeing for the next 10 years, I'm going to do this and this and this and this and this. This is your only get out of jail free card. And this is not even in the United States Code, because they don't want you to know about it. The only place you can find this is in the statutes at large. Same thing with the Forest Service. Any revision in present and future permits, contracts, and other instruments made pursuant to this section, this is their planning section of the National Forest Management Act, shall be subject to valid existing rights. Okay? This is the section in the Endangered Species Act that says you can kill an endangered species if you feel threatened or if you think it's threatening somebody else. Okay? We looked at this map at the beginning. At the beginning, you thought the government owned all this land. I'm telling you right now, about 90% of that, they only own the mineral rights or some commercial timber rights on 90% of that. You are the surface owner. That's what Congress calls it. Go read the Stock Raising Homestead Act. The Supreme Court said in Watt versus Western Nuclear, this is why they wanted to get rid of Jim Watt when he was Secretary of Interior. Because he brought that case, Watt versus Western Nuclear. And in there, the Supreme Court says that you are the service owner. That the Stock Raising Homestead Act was the culmination, the apex, the end all of this change in policy. So if you take the Stock Raising Homestead Act and you read that act together with the decision of the Supreme Court in Smelting Company versus Kemp, you read those two together, that tells you the whole story. It tells you everything. You own your allotment. You are the surface owner. The Stock Raising Homestead Act calls you the surface owner. And people say, oh, that act was repealed in 1976 by FLTMA. No. It was amended most recently in 1993 to grant you additional rights. If some oil or gas company goes on your allotment, starts drilling, not only do they have to pay for the damages to the surface and pay for any improvements they damage or water rights or forage, but after 1993 they actually have to pay you a fee every year. They have to pay you a fee for the loss of that amount, whatever amount of land they took. Okay? So here's my last slide. So wake up, wake up, wake up. Okay, last slide. When you own property in the West, you don't always own everything from the surface to the center of the earth. Someone else might own the minerals lying underground, and the right to access them. Someone else still might own the right to use the water flowing through your property. All this can invite confusion and litigation. Ours is such a case, a battle between ranchers and miners over property claims that trace back to separate government grants an age ago. This was written by Neil Gorsuch, recent Supreme Court judge. So we know at least one of them understands that the West is a split estate. Now, are they going to rule in favor of ranchers? I don't know. But until we try, we'll never know. And I had somebody, this has been 30 years ago, I had somebody from the Arizona cattle growers. I don't even know if he's still alive now, but I know he's retired. They said, what if we lose? What if we lose? Well, let's analyze that. Right now, what is the position of the BLM and the Forest Service? Do you have any rights?
Yes.
Do you have any rights as far as they're concerned? Their position is you have no rights. So my question is, what if you lose? So what? What have you lost? You got nothing to lose. You only have up. Because right now they say you have no rights. If you win, it's all up from there. You see what I'm saying? You might lose. What will change? Nothing. So it's better to stand up for your rights. It's better to fight smart. Now, I'm not encouraging anybody to go out here tomorrow and punch that ranger in the nose. Okay? Or to call him up and tell him to shove his permit somewhere. Okay? I'm not telling you to do that. If you don't have a fight, and then you don't need to pick one. If you're doing okay, if you're doing all right and you're semi-satisfied with the way things are going, then let us continue. Because right now we got court cases that we're working on right now throughout the West. And when we are done with those cases, we're going to have an answer. All right? But if your back is against the wall and you have no choice but to fight, we'll do whatever we can to help you out. Okay? But don't give up. Don't walk away. That's what they want you to do. They want you to get so frustrated, you just walk away from that allotment. You just walk away and say, that's it, I'm done. And you walk away. And so then what happens? What did the Supreme Court say? That an allotment is analogous to a homestead. The government thinks, these bureaucrats think, that if they can get you to walk away, that reverts to us. It does not. Once land is given, it's given. Once a right is granted, it's granted. So even though that allotment may be vacant, that allotment is cheat to the federal government. It becomes abandoned private property, just like a homestead would be. If this guy over here decided, I've had it with Glenwood, I'm going to Hawaii, and he just up and walks away, does that homestead revert to the federal government? No. Whoever wants to can go in there and either pay the back taxes on it, or they can go in there and just move in and get it by what's called adverse possession. Because I've had people say, well, what about these environmental groups? They're just going to swoop in and start buying up all these allotments and get them for a song because the Forest Service has reduced this guy down from 500 head to 5. That's not unrealistic. I mean, you've seen that kind of stuff, right? So then some environmental group's just going to buy it up and then they're going to have it. Well, guess what? If they buy an allotment and they don't stock it, they're not using it, you could just go move in and acquire it by adverse possession. So, you know, these environmental groups, they think they're going to pick up some of these allotments for a song. I've seen some of these new laws that they're proposing. Well, we're going to retire this permit. Retire the permit. I don't care. The permit's not real estate. The allotment's real estate. Okay, the permit's a piece of paper. Okay? So, that's my presentation. You probably are totally bored and don't have any questions, so. Oh, okay, wait, there is one.
Angus, I'm just trying to absorb all of this, and there's an awful lot to absorb, obviously.
Yeah.
But I'm just trying to think of a realistic possibility here. Most of us have been signing off on these grazing permits for decades. Does that give them some sort of a legal precedent when you're trying to bring it back to?
Thank you. Thank you for asking that question. There was a case in Montana about 7 or 8 years ago, the Roth case. Roth Ranch versus United States. The guy bought a ranch. He had a certain amount of patented land plus his allotment land, plus he had a reservoir, big irrigation reservoir in the national forest, and ditches and canals coming down, bringing the irrigation water to his farm. And the Forest Service said, you know what, we think that reservoir is going to be a nice recreation area. So you're not going to get any more water out of there. We're canceling your permit, and you can't use that water, and you can't use those ditches anymore. So Roth goes to court. He says, this is a valid existing right. It doesn't matter whether I signed the permit or not. I still own the water rights. I still own that reservoir. I still own all the ditches and canals and the easements and right-of-ways associated with that. That's property. And just by them canceling a permit because one of my predecessors in between the original guy that built it back in the 1800s and him in 2000, just because somebody took out a permit and they had permits going on ever since, that doesn't mean I no longer have a property right. And the federal judge agreed with him 100%. He said the Forest Service argument was ridiculous. Just because you sign a permit doesn't mean that you now lose your property rights. Property can only be lost one way: due process and just compensation. Until that happens, that property still exists. These guys that have been ran off of these allotments all over the Gila, I think there's a very good legal argument for them to make to come back. Okay? So I'm glad you asked that case. So the fact of signing a permit, according to the federal district court in Montana, is a ridiculous argument. Now, the Forest Service did not appeal that case. They lost, but they did not appeal it. And so you might say, well, why didn't they? Because if they appealed it and it went to the Ninth Circuit and was upheld, which they obviously thought it would be, that would just destroy all this mythology that the Forest Service has been trying to promote for decades. Okay. All right, thanks. Oh, other questions?
Oh, can I add just one thing? So,
yeah, go ahead.
So when we were down in Las Cruces here this last January, there was a couple of you who were there. One of the things that people always bring up at the end of Angus's presentation is, well, what can we do now? Because the problem is most folks, if you're like my family, it's one of them things like cattle prices stink right now. If we can make it to December, what's the old country song? If we make it through December, we'll be fine. Problem is we're in July. December's a long way off. Cattle prices stink. People on shoestring budgets already, and it's like, I can't afford some stupid attorney for $20,000. So what can we do? Angus has told us to step up, assert our rights. I can't afford to assert my rights. What can I do? And that came up multiple times when we were down there in Las Cruces. And I remember Bill Bullard with RCAF. Most of you probably know who RCAF is. And Bill Bullard said this is where the Range Allotment Owners Association needs to take the next step. And because that's the thing is most people can't fight the Forest Service or the BLM on their own. They'll squish you like a bug, and that's the sad truth, unless you've got the resources to fight them. But the Range Allotment Owners Association, you get people from all over the West, and it's only $50. And I'm not saying this because I get a kickback or something. I mean, I drove all the way down here because I believe in what we're doing. And so $50 a piece, you join Range Allotment as Owners Association, that association can now step in when one of you as an individual starts getting paid by the government. You know, and so collectively, you now have that voice and that power. So, and that sounds cliche, people are always like, oh, join the association will help you. But I think there's some truth to that. And really, I think that's kind of the next steps here, is you kind of think about and mull over, you know, and kind of digest what you've heard tonight. I think that's what you do with it.
And even if you're already a member, you can still give $50.
So.
Go ahead.
So, thank you guys. This has been awesome. And I have, my whole life, I've gotten so tired of hearing people say, oh, it says in the Constitution you can't own property, the government can't. You know, because it's obviously not working. Yeah. So I've always wondered, well, what's the other thing that you can do? So this is great hearing this. It feels good. Thanks for coming up with the idea and actually doing it. But another thing is so a lot of times we have, me and my family, we go and put cows, or we have gone and put them on whenever somebody has lost their grazing rights or whatever, and then the land hasn't been used for years. We've just went and put a bunch of cows out there. So how would you go about putting to take a prior appropriation?
This happens more often than you think it would, but there are people that, for whatever various reasons, I've gone to people and I've talked to them and I've explained, you know, you haven't lost your rights. That allotment is still yours. It's a matter of record that you are the allotment owner. And they said, well, you know, I may be, but I'm not really interested in putting cows out there anymore. I got beat up enough. It's not worth it to me. And then I've had other people that have said, well, what if I buy that from you? So for a small amount of money compared to what it would be if it was a fully functioning ranch, there's been people that have come and come to that guy and said, all right, if you quit claim your allotment over to me, then I'll pay you X amount of dollars.
Yeah.
And people have done that.
And I've done that.
What that does is it maintains the chain of title from
Yes.
the original allotment owner.
And that's what we did. We went to, because it was one of our cousins, and so we took his chain of title, and we went and gave it to BLM, which sounds like BLM and Forest Service, it shouldn't be much of a differentiation between our rights, from what you're saying, with the BLM. And anyways, I'll be damned if they didn't go ahead and give it away again to one of my other cousins, but she kind of had a little kickback deal. She was friends with the ranger, and so anyways, they gave it to her. And I've always thought there would be a case there to say, hey, you've taken our property rights. And my dad, they called my dad, and they said, you know, we gave the thing you were asking for to your sister. And my dad's all, no, I own those rights. I own those improvements. You know. Anyways, it didn't.
This is what I would do. This is me. I mean, there's several different strategies that I can see. But what I would do is I would sue your sister or whoever it was that they gave it to.
Go with my aunt now.
Your aunt, sue your aunt, and in state court. That's what I would do.
Oh.
And have
And
the
then-
state court decide who has the legitimate right to that allotment between you or her.
Huh. That's cool.
That's one strategy. That's one way of doing it. Okay. There's several things. You can go to her and say, listen, for you to just quit claim that over to us, what's your price? And that way you avoid litigation.
Yeah.
Okay, that's
Well,
one way.
in the
So
grand
there's
scheme of
there's
things-
several different things
Yeah.
you can do. But the problem is that these federal employees think that they have a right to do that. If you took her to court, you would force her to prove what authority the BLM has to give your cousin's allotment to her.
Yeah.
They have no authority. They have no authority to take your property and give it to somebody else.
Yeah,
You
they
see, but the
did.
problem is we don't know what our property rights are in the first place. They've been able to obscure that and confuse people with this public land BS.
So the other thing is like right now we're in the middle of, we bought a ranch that has a little sorry forest permit that goes with it. And the forest ranger point blank said, well, I don't really want you putting cows up there because it looks bad, the stupid road goes right through it. We don't want you really to have cows, but I guess if you put like 20, we'll just kind of not under the table, we'll just say you run 20 year round. So we're like, okay, whatever. But, they jack with you so much about actually giving you your permit, and they keep saying, well, we see signs of cows,
Well, do you
and
need a
this.
permit?
Yeah, exactly. I don't need a permit now.
See, now we're getting down to where people are starting to think for themselves and ask themselves, do they really have authority to tell me what to do? See, that's why we need an association like this, so that there's somebody that will represent you. Has anybody from the Public Lands Council ever done anything for the ranchers in New Mexico or anywhere else for that matter? They can't even get their name right, for crying out loud. Okay.
I was just wondering, I have a piece of property. I currently don't have an allotment, but right across the boundary fence is a forest allotment that's vacant. And it's been vacant. Does the base property requirement still apply? Do I have to have a certain level of base property to purchase
You
that
see,
allotment?
the Forest Service philosophy is that all of this land is permanently locked into a non-titled status, okay? And that all of this so-called base property requirement, that was required in 1879. But after 1890, when Congress validated all title, occupancy, entry, and settlement west of 100th Meridian, that was the end of it. And in 1891, when they passed the so-called Forest Reserve Act, the General Land Law Revision Act, Congress actually put in there that the Secretary of Interior only had 5 years to challenge any title, and if they didn't, by the end of 5 years, they were forever barred from challenging your title. So our whole position is, your title is perfected already, or the title of these allotment owners is perfected already. If that guy abandoned his property and you wanted to acquire it by adverse possession, and you were so predisposed to do so, knowing that you will probably get a lot of grief from the Forest Service, but if you're prepared, there's a scripture, I can't remember the reference, but if you are prepared, you shall not fear. And that's what we want to do. We want to prepare every allotment owner. We want them to be so knowledgeable of their rights that when you walk out of that Forest Service office, that guy's going to be scratching his head and say, what in the heck are they talking about? Because I can tell you right now, they know none of this. They are clueless. You could show them a copy of U.S. versus New Mexico today, and they'd say, you don't own any water rights, because they try to keep their employees ignorant. That's their whole, because you're going to be banging your head against the wall saying, can't the stupid Forest Service BLM person understand anything? How can they be that dumb? Because they've been trained to be that dumb. And when I started learning all this, you better believe I got a lot of pushback from Dave Stewart. I don't know whether to cuss him or thank him, because I learned so much from that guy. But I talked to him one time, I said, don't you believe that these ranchers own their water rights? Here's U.S. versus New Mexico, black and white, right in front of you. And he said, maybe they do, but I think the Forest Service should own everything. So we are living in a world of communist socialist mentality, where people think the government should own everything. And there are people that are jealous of you, that covet what you have, because you have a big ranch even if you're going in the hole $20,000 every year. They covet you, what you have. Even though they haven't worked for it and they haven't earned it. That's the kind of world we're living in. And there is an army of bureaucrats. I think there's, I can't remember, it's 30,000 or 60,000 people who work for the Forest Service. Okay? And when I asked Dave Stewart about it, he said, we've got jobs to protect. I said, can't we just recognize these guys have property rights and just deal with it? Work around it, do whatever you have to. We still own the timber and we own the minerals, and we can just work with these people. So, we got jobs to protect. That is their whole mentality. That is the way a bureaucracy works. So, my answer to your question is, I think there's a perfectly legal way for you to acquire that allotment by adverse possession. But you better know what your rights are, and you better be ready to defend them in court, because the Forest Service is not, they will, you know what? It doesn't matter. If they were faced with absolute positive proof, they'd still fight against it. Because they have jobs to protect. They're protecting the bureaucracy. The idea that the Forest Service would ever go away is horrific to them. They'd wake up in a cold sweat at night if they had that nightmare.
And you're facing the Department of Justice, not the Forest Service.
Well, that's why we have done the most extensive research that we can possibly do. And we are backing ranchers right now that are willing to assert their rights. So we are going to find out, and you know what? This isn't new. Just 2 years ago, in 2017 in South Dakota, a federal judge the government was prosecuting a rancher for illegally grazing on federal land. Well, that was perfect. And our assertion was, he's not illegally grazing on public land or federal land because it's a grazing allotment. And in a grazing allotment is private property. It is not federal land. And we won. And that was just 2 years ago. So this isn't make-believe. This isn't pie in the sky. You've seen everything that I've showed you up here. I could spend a whole week going over every single one of these laws with anybody that wanted to. Okay? And you would see for yourself. But that's why I put these laws up here. That's why I give the citation, so people can look it up. And they can find out, well, gee, at the very minimum, here's the very minimum. At the very minimum, in 1912, Congress ordered the Secretary of Agriculture to dispose of all land in national forests under the laws applicable thereto, which was split estate laws. In 1914, in his annual report to Congress. Now some people say, well, Angus, that's just an interpretation. Well, guess what? It must have been the Secretary of Agriculture's interpretation also. Because in 1914, in the annual report of the Secretary of Agriculture to Congress, he reported that by the end of calendar year 2014, that the Forest Service had disposed of all grazing rights in the national forest. So that must have been their interpretation also. It's pretty plain. There's no question. So, any more questions?
Angus, can I say a couple words?
Yes, sir, you can after I answer Marilyn's question.
Oh, you go right ahead.
So the 25, 25, 50 that we pay, so we've asked the county if they get that money and they do not know where it comes. They said, well, we get pills, we get our payment in lieu of taxes, but they don't know that they're even, is that law still applies, doesn't it?
Yeah,
25,
it has
25,
not
50?
been repealed.
See,
It's
none
not
of the
been
county
repealed. As a matter
commissioners
of
even
fact,
knew anything about it.
The forest, the laws relating to national forest and to BLM were combined by the Federal Land Policy Management Act of 1976. Those two laws were combined into one law, so that originally that grazing fee going to the National Forest was one thing, and the grazing fee going, going to
But it's
BLM.
implement, right?
It's the same law, same fee. If you're getting payment in lieu of taxes, that's your 25% fund. That's your 25% that is supposed to go to
And we're
roads.
supposed to be getting the 50 back onto
Yeah,
our
and
allotments.
the 50% is supposed to be going to the allotment owners. That
So
money's
how-
supposed to be.
So how do you figure
That act,
that out?
that act actually says if they don't spend that money for improvements, you can ask for a refund. That's what that law actually says. But because nobody's ever brought it up, I guess they spend it on a kegger for their firefighters
Well,
at the
they
end of the year.
probably on another
But if they have,
range con.
just to make sure, if you've already signed the grazing lease for every 10 years and all
Well,
that,
permit,
your permit,
you can.
Yeah,
you
yeah,
know,
not lease,
here's-
your
under-
permit.
Under section 15 of the Taylor Grazing Act, you can lease land. Okay, so I've had some people try to tell me, well, my allotment's really a lease, except for one thing. Section 15 is very clear that it only applies to 720 acres or less. So there are people who probably lease some isolated parcel from the BLM somewhere, but it's not an allotment. It's because it's got to be less than 720 acres.
So if you've
Okay.
already signed your allotment for.
So your permit,
Your permit,
okay,
if
permit.
you've already signed your
contractor-
permit, then it doesn't take away your rights, it's just that, that's kind of their, how we always
They
said, that's
will-
why we
they
get them to
will-
sign this
They will
thing.
try to enforce against you. 9 times out of 10, they won't accuse you of trespassing on government land. What they will do is they will say you are in violation of the terms and conditions of the permit. So 9 times out of 10, that's what they're getting you on. They're not getting you on trespassing. They're getting you on violation of the terms and conditions of your permit. So now we're going to hear from Chuck Sylvester, co-founder and my mentor and my good friend.
Well, Angus, you very complimentary. The compliments go to you. A great presentation. And it's good to see you people. I was one of those back in '73 that signed something I shouldn't have. Agreement giving up 45% of our range so they could improve it. And the agreement, they said they would only run 250 feral horses. The ink wasn't dry and they were shipping in horses. They wanted our 45% to graze their horses. But thanks to meeting this guy and taking a stand and a wife, a good rider, that agreement is no longer in effect. And we need to get the word out. And he talked about the Wyoming stock growers, and they asked me, been a member 50 years. I don't always agree with their policy, but there's a lot of good ranchers there, and that's who I enjoy being around, because they're the best people on earth. And but a few years ago, I was a committee chairman of water or something, and they wanted me to talk to the federal lands, and a lot of BLM people in the audience. And I told my story, what happened on that agreement. And I said, you good employees, you know who you are. At BLM, it's still applicable, Bureau of Land Management. But to some of you, BLM, it's not Black Lives Matter. It's the biggest liars of mankind. So sometimes I have to vote. And as far as attorneys, I have nothing against attorneys. Some of them are my best friends. I socialize with them. I pay fees, getting paperwork and stuff done. But it's sad. And he talked about the case there that's burning. The Hammonds in Oregon, they were arrested with burning on their allotment. Well, they got an attorney to represent them that didn't know the facts, and they were convicted by another attorney judge. But heavens, we got a president that listens, and they were pardoned. You heard about the sheepmen up in Idaho being kicked off the forest. And in Greeley, where we've got a big lamb feeder, and they have their own packing plant there, Harper, and they buy lands from all those people. And I said, young Mike, who are those people? Do you know them? Yeah, he says, buy. I says, they shouldn't be kicked off. They've got rights. And could you tell me the names of some of them? And he did, and he says, but this is the one you should call. And I called him and talked to him for a half an hour. And he says, oh, we got this attorney firm. I said, sorry, sir, that attorney firm won't help you. You're doomed. I offered to pay his expenses, travel to go up there and visit with them and tell them about their rights. But unfortunately, he said, one guy that kind of runs it strong-headed, and he won't listen to the rest of us. You know, they're now out, some of them out of the sheep business. And I lived in Idaho a year. I loved the state, got to know a lot of the ranchers and the sheep men. And the ranch I worked on, there was a little tad running around here, whatnot. He happens to now be the governor of Idaho, Brad Little. I worked on his dad's ranch and feedlot. And but again, attorneys know law, but they don't know what this man knows. Policy and statutes, how they're all established. And what's sad, one of the family's attorneys, both of them, that we socialized, Ronnie and I, done things with them and got into a heck of an argument at the stockyards with the man one time. His wife works for Perry Penley down in Grand Junction now, and they don't understand all the facts that this man knows. And we've got to get the word out, start telling your allotment owners and telling everybody. They need to listen up, get involved. I went over here to a little store of refreshment and asked what I was doing in town, and I said, I'm here for the allotment owners. We'll find out that they are allotment owners, and I said, you need to be here tomorrow. Come over and learn your rights. We just need to figure out how to approach and get more people. I still remember the NCBA. I go because there's good ranchers there, and I enjoy their convention, but the public lands, they don't know what's going on. They don't understand all this. So again, we need to listen to this man and start telling people and spread the word. If you tell 2 people, tell them to tell 2 people. Spread the word, and we'll have a great organization. We'll stand up for our rights, because you are great people, and I want to help you.
Any other questions? Getting pretty late. Are we past 8 o'clock yet?
Are we? Not our time.
Did you tell them about the stickers?
Oh, there's some stickers over there. Range Allotment Owners Association bumper stickers over there. $5. If you can contribute anything, we'll take whatever you can over there. Just drop it in the donation box over there. But join our association, go on to our website. There's all kinds of information on there. If you join the association and you ever have a question, you can call me directly. My number's on the website. Call me and say, well, I got this problem with this or that or whatever, and I'll do everything I can to help you. So, thank you for coming, and have a good evening.